welcome back. We're going to be covering sales and lease contracts under a massive body of law known as the Uniform Commercial Code. Now, this is a illustration of how common law contracts can be altered by statute. So I'm showing you here a link to the general Uniform Commercial Code. A couple of things. As I said, this is a massive body of law. Every state has adopted it to some degree. It covers sales law, leases. We're going to be talking about negotiable instruments, which are loans or checks. We're going to be talking about secured transactions. That's where someone lends you money and it's secured by goods. Now, I'm not going to get into the minutiae here, but just so you understand, this is the foundation for Uniform Commercial Code. Every state has adopted it. So state of Washington has it in their statutes. They can make some modifications if they want, but it's critical to understand sales law and the other ones we just mentioned. And it is a, I think, an area where a lot of people are not educated about it. So like I said before, we're going to be talking about the life cycle of a sales contract or lease contracts. The thing is here with sales law, which is the way to the term that's most apropos is that it deals with goods. Now you can't have a situation where the sale includes goods and services, like maybe you buy a carpeting. When you buy it at the carpet store, it's a good because it's tangible and movable. Those are key. Sales law does not govern real property. That's governed by other state law. So sales law, you can have a situation where you have a combination of goods and services. The key question is, what's the predominant purpose? Is it the good or is it the services? So you buy carpeting, it includes installation. You look at, would you buy the installation independently or could you? You probably could. So you could say that the primary purpose or predominant purpose is the sale of the carpeting, the good. And remember, when you talk about goods, these are tangible, what's called personal property, tangible, movable personal property, not real estate, not what are called intangibles, like intellectual property or accounts receivables. Those are not governed by sales law. All right, formation. Again, this is a modification of common law contracts. And so there's some critical distinctions. In common law, the offer has to be sufficiently specific. Under sales law, if the parties agree, specificity isn't fatal. You can agree to buy something at a market price when the product comes to market. You don't necessarily know what it is now. That's okay. So understand the Uniform Commercial Code loosens some of the constraints that were imposed by common law. Acceptance, again, in common law, mirror image rule. If the party, promisee deviates from the offer, then it's a counteroffer. Under sales law, a party can accept and actually breach at the same time by sending goods as an accommodation. What do I mean by that? You want to buy 40-inch plasma TVs. The seller send you 50-inch, which is not perfect, but you may take it. So it allows for easy modification of a sales contract. Under common law, modification of a contract required new consideration. Under sales law, modification does not require new consideration, albeit you do have a statute of frauds, which says any sale of 500 or more has to be evidenced by some writing. So that would also include any modification that's 500 or more. I mentioned consideration. Again, the big deal there with sales law is you don't need it for a modification of a contract. Statute of frauds, I already touched upon that. Parole evidence, this is the idea that if you have a contract and the contract has a clause or a paragraph that says this is the complete understanding of the parties, there's no other oral or written understanding, that's it. However, if the contract has some ambiguous terms, like you buy a car and the seller, you think the seller's going to put in a sound system, a high-end sound system like Bose, and they give you a Radio Shack cassette deck, that can be properly litigated despite the clause that says this is a complete understanding. By the way, that clause is called an integration clause because it integrates the entire deal into the final agreement. Another thing about parole evidence is it excludes, if you have a written contract, as I said, it would exclude oral promises that are not somehow incorporated in the final product. If a contract does not have an integration clause, then any and all communications are fair game. And of course, the parole evidence rule does not prevent evidence of subsequent agreements. I mentioned before unconscionability. This is where the sale or the lease of goods has certain conditions that are so outrageous, it's a normal person wouldn't have agreed to it. So understand, sale under sales law is defined as the passage of title, and title is ownership. Like I mentioned with real property, you have a deed or title to real property tells you who owns it or who has an interest in real property. Similarly with goods, you have certain evidence of title that will evidence who the transfer of ownership for from a seller to a buyer for a price. And there are various types of documents of title. I mentioned these here. Warehouse receipts, bills of lading. This is where a warehouse receipt, for example, is you get a receipt and you're told the stuff you bought is in the warehouse. And this is important because once you have title, you're responsible for any loss. That's why you have insurance. You'll see under sales law, there's certain defaults or presumptions, one of which is that if you buy something, it'll be what's called a shipment contract, where the you, as the buyer, are liable for risk of loss once it leaves the seller's place. Destination contract, you may see the term free on board. There's other terms, but this is where the agreement says that the seller is going to be responsible for the risk of loss and ensure that the goods get to the buyer. Okay, performance and breach. I mentioned this is a biggie, the perfect tender rule. So even if you buy something on Amazon or Craigslist or whatever, and you get it and it's not perfect, you need to inspect and reject and hold it. Don't use it. I should say sales law applies to all sales, but there are particular rules with respect to merchants. A merchant is somebody who um, is in the business of selling that product or holds themselves out as having specialized knowledge, like maybe you go to a veterinarian and they sell uh, pet food on the side. Now, this is all important because you'll see I'm going to be discussing warranties. They are very important. Important to inspect and timely reject. Don't use the goods. If you use it, you bought it. Remedies depends on where the goods are. If they're still with the seller can just revoke. The seller can cancel the contract, etc. If it's in transit, it depends on the contract, and it's a shipment contract or a destination contract, etc. Two important terms in sales law is that the if there is a problem, uh, the seller can cure the problem within a reasonable time, unless the contract says they don't have that right to cure. Likewise, the buyer, if they're suffered some sort of damages, they have an obligation to mitigate or cover their losses. So cure for the seller if there's a problem, cover obligation for the buyer. All right, so various warranties. This is the big deal with sales law, express and implied. So express warranties include that the seller actually has authority or title to sell the good. Um, and implied warranties include the implied warranty of merchantability, where the seller is a merchant, and this is implied that the goods are merchantable, can be used for the purpose or sold for. Um, and there's another implied warranty of fitness for a particular purpose. And this applies to all sellers. But if you buy something and your neighbor tells you the product or the thing can be used for a particular purpose and it's not fit for that, that's a breach of this implied warranty. I will say that these can be waived, and sometimes you'll see that, like with the used car lot, they'll have a big fluorescent sign in the window saying no warranty of merchantability, basically as is. So that's possible. So anyway, that's the wonderful world of sales law, and